We interrupt our amateur cornhole match between the Texas Tornado John Stevens versus Ice Ice Jay Regier to bring you not one, but two professional athletes in front of a judge. First up was Chad Curtis. This ex-New York Yankee turned felon served 7 years for sexual assault. Now, he is trying to receive custody of his children. Then we hear a lousy defense from Hulk Durham, an NBA and Japanese basketball player who has just as much luck in court as he had playing time. On the court, not much.
Very good. Okay, this is a motion for joint legal custody, parenting time, and child support review.
A former West Michigan success story, now a stunning fall from grace. Chad Curtis boasted an incredible resume as a major leaguer for nearly a decade. Fast forward to today. He now faces 7 to 15 years in prison, convicted of sexually assaulting teenage girls. Before that,
and I did review this case and the past histories and things of that sort. It looks like we got a lot of stuff going on here. So I have a motion by Mr. Curtis regarding physical custody for his 14-year-old and having specific parenting time, and he would like joint legal custody. And mom wants to move to Arizona because she previously had an order from 2018 to do that. That order is stale. And so if there's a new request, we can have an evidentiary hearing on that issue. So at this time, I think I need to hear from Ms. McClure in terms of a response to the motion by Mr. Curtis, since I've already basically given my ruling with regard to her motion.
All right, thank you, Your Honor. Regarding Mr. Curtis's request, we will acknowledge that the party's son, C, has been residing with Mr. Curtis primarily due to behavioral issues in the home and my client's fear for the safety of her daughters. So we will acknowledge that that is probably appropriate at this time. I think the parties are also in agreement that a child support review is necessary in this case. Regarding legal custody, I don't believe there's been a change in circumstances to revisit legal custody. My client has had that. The only changes that have occurred, regarding the party's son, yes, there has been a change, but regarding their daughters, there's really been no change. My client looks back at her calendar to track how much parenting time Mr. Curtis has had with their daughters, and she has basically given him any parenting time that he's requested. And he's requested about 1 day per month. I think he sees them at events and things like that. So he certainly has a relationship with them, but he certainly doesn't have the amount of parenting time that he is requesting. We have concerns about a felon living in his home. I think the parties have kind of agreed that the fathers will not spend the night in that home. So I just want the court to be aware of that and consider that.
Okay. Ms. Bryan, anything you needed to add?
Well, Your Honor, he's had substantial parenting time with the daughters for a long period of time, ever since he was released from prison. And sometimes he's taken the daughters for weeks at a time, one time to facilitate a vacation for the mother, other time that he vacationed with the children. You know, he was very surprised to see her claim about the limited time this year. He's had overnights before with the children, alternate weekends, things such as that. We can certainly go to front of the court, and the front of the court can make a recommendation as to the long-term schedule for the girls, but there's definitely been a change in circumstance to warrant the court's consideration of joint legal custody. One is that at the time of the judgment of divorce, he was incarcerated, now he's out. He would present to the court that the parties have had lots of discussions, joint discussions about their children, one of which was the moving of their son, selection of a high school for the son, things such as that. And he's very involved with the children. He didn't have the involvement at the time of the judgment of divorce because he was in prison at that time. So we think there is substantial change in circumstance for the court to consider the joint legal custody. You know, I understand that there's different burden of proofs with respect to that, but that's not before the court today. But the court could also refer the issue of joint legal custody to front of the court as well.
Okay, I just want to make sure I'm clear. The two of you are agreeing that the physical custody of the son is okay to change.
Yeah.
And there's an agreement that there should be joint legal custody of the son.
Yeah.
Okay. So what I'm going to do, as I previously have said, I'm basically denying the motion with regard to moving. And I would expect that there be a new motion filed if you want to change domicile. Do you understand, Ms. McClure?
Yes, Your Honor. I guess I would ask that the court consider our motion as a request for a change of domicile.
But then you have to plead new stuff. It's been 5 years. There's a lot of changes here.
Yeah, I think that the part of the issue is that my client was told that she did not need to file a motion for a change of domicile.
Well, I don't know who told her that. I'm just telling you that from this court's perspective, I need a new motion with new factors, facts as to why is there a request for a change, because everything's different from 5 years ago. So I would need a new motion for that. So I am basically denying your motions for relief on that 2018 order and directing that if in fact she wants to pursue a change of domicile, she needs to file a new motion. And I will need an order to that effect, which I want Ms. McClure to do. Perhaps you and Ms. Bryan can combine everything in the order that she is preparing that is going to, because it's going to require both parties' signatures, changing the physical custody and making it joint legal custody for the son. And then I will prepare a friend of the court evaluation, order of reference, on the issues of legal custody, parenting time, and child support. And the parenting time, I'm going to presume you're going to want to have a recommendation as to the mother's parenting time for the son.
Yeah.
Pardon, Ms. McClure?
Yes, please. Thank you.
Okay. And I think that plus they'll review child support. So that's the type of orders I want to see. I'll do the order of reference to friend of the court. Each party is going to pay $150 for that evaluation. Is there anything else that we need to do today?
Your Honor, could we also include in the order that on an interim basis that Mr. Curtis could have alternate weekends with the girls and one evening a week? I know that the mother complains about another roommate of his that's in the house, and that roommate is moving out on June 1. So that certainly the overnights could be after June 1.
Ms. McClure?
We're not in support of that request. Again, there were significant concerns of behavioral issues between the son and the daughters. My client has pretty serious concerns about those children being together unsupervised, in addition to the person who hopefully is moving out on June 1st. So we would ask that the parenting time provisions remain as it is by agreement of the parties until we have established a specific schedule.
Well, you do understand, friend of the court will look at whether or not the parties are able to agree while they're coming up with their evaluation.
I understand that.
Okay, well, I'm not going to make a change in the parenting time because we're just sending this all to friend of the court to figure it out, but that's my admonishment there. Anything else?
That's all. Thank you, Your Honor.
Okay, thank you very much. We are adjourned.
One other thing, Your Honor. I do have another motion before you. I don't know if I could come up soon.
I don't know. Who is it?
It is the Parks versus Durham file.
Well, I don't even know if I have that file in my office. Let me take a look.
Okay.
Because when you have 50 motions, you don't get all the files all at once.
That's the good news, right?
Yeah. Is it in here?
And Chad, you can log off.
Okay. Well, lucky for you, my clerk came running in here, dug through the pile and found it for me. So let me get to my notes. Durham, case number 2207462DS. And I see we have Ms. Parks. We have Ms. Cook. Are you here on behalf of the plaintiff in this matter?
I am here on behalf of Mr. Durham. Mr. Durham is in the waiting room, Your Honor.
Defendant. Okay.
アレンダーラムのペリメーター。ダラム選手も入ってね、来てすぐシュートを守りました。名古屋いい形作りましたけど。
Okay, I'm sorry. I was a little confused by some of the pleadings. I wasn't sure if you were still on it or if somebody else was. So, Mr. Durham, we just need to get him out of the waiting room.
I recently entered a substitution, Your Honor.
Oh, okay, thank you.
I'm here.
Oh, good, thank you very much. Okay, this is Ms. Bryan's motion to compel on behalf of the plaintiff. I did receive her motion, but I did not receive a response, Ms. Cook.
We did not file a response. We'll respond verbally. Thank you.
Well, you're going to have to be very brief about it because we have quite a crew here today.
I understand that.
Ms. Bryan, is there anything else that you need the court to know?
Just that we had the scheduled trial April 5. I bet you remember the case. The defendant is a professional basketball player. We learned that he hadn't included all of his income on the tax return. That was learned on the day of trial, but it was agreed and included in the order that he would produce that additional information so we could rerun that. I've asked several times to obtain that information from his prior counsel, basically got no response. And then a new counsel came in. The other part of this is the attorney fees. We were hoping to resolve that, and it's provided in the order that if there's no resolution that we would have a hearing on attorney fees. I've asked Attorney Cook to merely stipulate to that hearing so we can get that on the books. I haven't received a response to that as well. So I'm here today to get his additional income information so we can rerun those guidelines, the employment contract, and then also if we could please have an evidentiary hearing on the attorney fees, and I would think that we could get through this in an hour.
Okay, Ms. Cook.
Thank you, Your Honor. In this matter, a couple of things. I note that on the UCSO that is dated, I believe, January 1 of 2023, the defendant will supply plaintiff's counsel with all of his current employment contracts. It's my understanding that Ms. Bryan has the employment contracts for 2023. That's what would be relevant under the UCSO that applies to that, as well as what's pled in Ms. Bryan's motion. If there's an additional employment contract that she believes applies to 2023, we would certainly provide it, but my client only works for one team at this point in time and has all of 2023 and all of 2022. So I don't think that there's anything additional she needs there. My understanding, there's no outstanding discovery. In other words, interrogatories or subpoenas that have not been responded to. I have not been supplied those. If they are out there that have not been responded to by prior counsel, I certainly would do that. Secondly, as far as the attorney fee issue, we recognize that there is an order reserving the attorney fees. Of course, the court has to comply with the Wood factors, has to be pled, billings have to be provided, and we would like time for discovery on that issue to determine whether or not the attorney fees are reasonable. I also want to have an opportunity to retain an expert if necessary. So if the court's going to schedule that for hearing, we would ask that that be set out in 60 days so that I have time to comply with discovery. Thank you.
Ms. Bryan?
I don't mind if it's 60 days from now. I mean, these are just more attorney fees that he's going to end up paying for, so we can take care of that. I have no objection to that. I didn't really hear the answer about the additional income information, which is in the UCSO that applies effective September 1. And just as a refresher, he had employment in that year from 2 basketball teams. His tax return only reports income from 1 basketball team. We all know that he had income from the 2nd basketball team, which is referenced in the motion, so he needs to supply that. And I didn't hear any response on that part.
Happy to respond to that, referee. My understanding is that he worked for another basketball team in 2021, not in 2022. So the reference to the UCSO that indicates he supply additional income information under the September of 2022 order would not be relevant to a team that he worked for a few months in 2021. So once again, I don't understand the relevancy here in regards to anything he did in 2021. My client additionally, just so that Ms. Bryan knows, has made attempts to get information from this Japanese team that he played for in 2021 for a few months. He has gotten no response. We can't issue a subpoena. I don't have the ability to get other additional information from this team because the only contact that he has is not responding. I don't believe it's relevant, and we've done everything we can to secure the information from 2021, which has nothing to do with the 2022 UCSO that indicates additional income information.
Well, just so we're clear, when we established the 2022 child support obligation, we used his income from 2021 to do that. And that's part of this whole difficulty with substitution of counsel, even though Attorney Cook may not know that, but certainly Mr. Durham does. With respect to, I'm not getting an answer to my request defense, most certainly he has his income statements, his bank statement showing his stream of income. He could show us that. He received additional income, apparently not paying a dime of tax on it because he never reported it on his tax return. And there's certainly ways that he can show us what his additional income was from that 2nd team. It's not denied that he worked for the 2nd team, and it was contemplated that we would get that income information. I bet the referee even recalls that. So it feels like this is an end run on a stipulated court order. With respect to the employment contracts, again, I understand that Attorney Cook is substituted counsel, but we had 2 different forms of an employment contract. And that's why he was ordered to present all of the employment contracts from 2021. He gave one version to Ms. Parks. He gave another version in answer to discovery. So there is something up with respect to his employment contracts, and he can answer those questions. We can have him answer those questions at the time of the evidentiary hearing. So now the evidentiary hearing is not 1 hour, but a half day. We can have him answer those questions, but it's already part of our court orders. I don't think it's appropriate to relitigate what was part of a stipulated order.
I would just like a final statement here. If I look at the UCSO dated January 1 of 2023, it indicates he's to provide current employment contracts.
I've already heard this argument, and it's not flying with me. Ms. Bryan is correct. He had to provide income information from 2021, as well as supply a complete copy of all employment contracts he has signed. Bottom line.
If I might, Your Honor, it doesn't indicate in these USCOs that it's for 2021. There's absolutely no reference to that. That is not the order of the court, and these orders were drafted by Ms. Bryan. So respectfully, it doesn't indicate that he has to produce 2021 income. It also doesn't indicate he has to produce 2021 employment contracts. It states current employment contracts on a UCSO that's dated January 1 of 2023. My client is not in violation of any orders.
I didn't say he was in violation. But, Ms. Bryan, do you have a specific order that states that basically puts forth the understanding I recall from this case, as well as what you recall?
Actually, what I think what we could do is order the transcript of the agreement that we placed on the record. And just so Attorney Cook is aware, these are UCSOs that Mr. Durham's counsel drafted. I didn't draft it. I approved it. I recognize that. But I can order the transcript, and we can argue this at the evidentiary hearing on attorney fees.
I did order the transcript, Referee Perry. There's nothing on the transcript about it because these folks not go on the record. We started it, they started it, and then Mr. Durham, because it was 3 a.m. in the morning, did not come back on after there had been a long pause. Nothing was put on the record.
Well, okay, but there were reserved issues.
Well, it was reserved only through an order that was signed by my client's counsel and not my client. Nothing was put on the record. I have the transcript.
Oh, okay, we're just gonna have a whole new evidentiary hearing then, on all the issues, Ms. Cook.
I would agree with that, Your Honor.
We're gonna have a whole evidentiary hearing on this.
I would agree that that would be
Do you have a
appropriate.
date and time?
I'm sorry?
I'm asking my clerk, Ms. Klein, to give us a date and time.
Yes, Your Honor, I put it in the chat. I have,
No, I'm sorry, I can't be looking at chat when I'm having a conversation with parties.
I understand that. June 27th from 1:30 to 5.
May I have a moment to confer with my schedule?
Just very briefly.
Yes, ma'am. It will take me a second.
I'm free.
Thank you, Ms. Bryan.
Will you do me a favor? 1 second, Your Honor. I'm just gonna have someone in my office check on that for me. It'll take me a moment to pull up my schedule, so they can do that. June 27th, 1:30.
And Your Honor, may I ask a question because I can just see where the direction is going? You're saying a hearing on all the issues raised in my motion. You're not
Yes.
suggesting that we are revisiting child support.
No, we're not revisiting child support. We're just the reserved issues raised in your motion.
Thank you.
Your Honor, I would ask for additional time just based upon the fact that I need 60 days for discovery in regards to attorney fees and reasonableness and to retain an expert.
August 29th at 9 a.m.
Says it's even scheduled to.
Okay. Check August 29th at 1, please.
I'm free August 29 at 9 a.m.
We're checking, thank you.
Just to be clear, it's August 29th at 9 to noon.
I'm sorry, I didn't hear the clerk. From 9 until when, ma'am?
9 until noon.
Excellent, thank you.
Ms. Bryan, did that work for you?
Ms. Cook?
Yes.
Okay, that's what it will be.
I'm sorry, can you repeat that, Referee Perry?
August 29th at 9 a.m.
Thank you.
until noon. We're having an evidentiary hearing on the reserved issues in Ms. Bryan's motion. And Ms. Bryan, would you please do the order and notice that out?
Yes, I will. Thank you, Your Honor.
Thank you for your time, Your Honor.
Thank you. We are adjourned. And then Ms. Cook, do you have another hearing with us?
I do, Your Honor, thank you. It is the matter of, my client's in the waiting room.
Yeah, Oliver versus Phillips.
Yes, Oliver versus Phillips, thank you.
Okay, we'll do that one next. And that is case number 1402169VP.
My client was in my waiting room. She'll be with us in a second, Your Honor. But we didn't.
Is there a Jason Oliver or anyone on his behalf?
Well, I apologize, Your Honor. I had trouble hearing you. May you repeat the question?
I'm asking if there's a Jason Oliver or anyone on his behalf here today.
Mr. Oliver is incarcerated. However, there is a guardian that was appointed about a week ago. It's my understanding that counsel for that guardian is appearing in this matter.
Okay, and is there an attorney Bernal?
That is the counsel for the guardian?
Yes, I do know that
I'm sorry.
because they did file a response. Well, I guess I can't hear your case right now.
Understood, thank you. We'll go back and wait.
Okay, thank you.
Thank you for tuning in, and don't forget to like and subscribe to Time Served. You have been served.